Hello there, I'm Ali Fiddy, the Chief Executive of IPSEA. We're a national charity that provides advice and casework support to the families of children and young people with special educational needs and/or a disability. And I'm delighted to be joined today by David Wolfe QC
Hello.
and Leon Glenister to talk about the Noddy Guide. So David, could you just start by telling us how the Noddy Guide came to be originally?
Yeah, so I've been involved in sort of SEN Law and SEN tribunals for over 30 years now. I was briefly in the early 2000s what was then called a tribunal chair, now tribunal judges. And in the middle of that period, the then president of the SEN Tribunal, Rosemary Hughes, who some people might remember, came to me one day and said, David, could you produce, and she used the expression, a Noddy Guide, could you produce a Noddy Guide for tribunal chairs? I was a bit surprised at that because I thought, well, some of these people have been judges for 10 years at that point. Do they need a Noddy Guide? But anyway, I did it. And I produced the first one as a training material for judges at that point in 2006, and it was about 10 or a dozen pages long. So that was the original Noddy Guide.
And of course now it's much longer than that, much more complicated, and it's evolved really over the years, hasn't it? How has that kind of evolution taken place? Why is it now much longer?
Yeah, so I sort of took the view that I wasn't going to do lots of changes to it every time a new case came out. So basically, it actually coincided with a big annual conference that used to be held, or still is held in the spring every year, an SEN conference. So each spring, I would update the guide for the conference. I think my experience was that actually very little dropped out, and we just got more case law, more complexity, and we got the 2014 Act and so on, all that extra complexity. And so it gradually just grew from 8 pages to something over 100, but always in that period as effectively a PDF that was available to people free, online, printed out if you like, but it was basically fundamentally a document, a physical document.
Sure. And how did it end up being a collaboration between you and Leon?
So I remember taking the Noddy Guide in a printed form to tribunals when I started, and that would always be my sort of pocket. I had the Code of Practice and the Noddy Guide, and at that stage I think it was probably about 50 or 60 pages. And I noticed after the 2014 Act, which changed a lot of the law, there's a bit of a, I think David won't mind saying, a bit of a delay in it coming out. And so I said to David, would you like me to help you update it? And he graciously accepted. And
grabbed it with both hands, I think.
Grabbed it with both hands. And so then we've worked together since then on the guide, and we've taken the 2014 Act and used that alongside the old provisions for Statements in Education Act 1996, and this time it's a bit different.
Yes, and can you tell us a bit about what it looks like this time? Because it is kind of a rewrite, but also a sort of relaunch in a very different format, in a kind of collaboration with Support Send Kids, as I understand.
That's right. So we, if you're keeping close on the legal provisions, what's happened now is that the 1996 statement law has edged out completely, so we're now really using the 2014 Act, and the Welsh legislation's gone a slightly different path. So we have made the guide as a whole to focus on the 2014 Act. So it's undergone a rewrite, but probably more excitingly, we were approached by Support Send Kids to upload the guide in a digitised format, so it's available in a different way, so you can ask questions on the site and people can respond to different answers, and sort of jump around it a bit more, which was not possible with a plain PDF. So we're looking forward to now having it in a different way. So hopefully, if you're, whether you're a lawyer or whoever it is outside tribunal, you can look up your question on the internet in a much more accessible way, and it will hopefully also reach a wider range of people.
But it will still exist in that PDF format as well for people that want it in that format too. So it's intended to kind of capture everybody in respect to the kind of accessibility of it.
Yes, I mean, the PDF has always been the lazy way of doing it over the years. I had been thinking a few years ago that in the modern world we really ought to have this in an online version, not just download a PDF, but something more accessible. Didn't have the sort of time or the energy or the wherewithal to do that. So it was great to be approached by Jambi and Rachel and others from Support Send Kids last year, with their idea that they would put the Noddy Guide into this form on their Senate product, and that would be a good, good for them and good for us and good for everybody else as well. So it's sort of opportunistic, and it's been a great project to work on. We've been doing it now for 9 months, this new iteration, so been good.
Really is a baby, in fact.
Yeah. We're glad to get it out the door.
Indeed. And just thinking about that kind of the process that you've gone through with the Noddy Guide, since you said it was first drafted when you were asked to do that, and the kind of the intention at that stage was for it really to be used by kind of tribunal kind of chairs, wasn't it, at that point? And it's quite different now in terms of that audience. But obviously, you've touched on the fact that there's been a lot of change within the kind of legal framework in the years since you launched that Noddy Guide. And I guess it might be nice just to have a think about those and reflect on some of those changes and the developments that we've seen. And I mean, from my perspective, I think it's so much broader than just the SEN Law framework. I think we've seen the decimation of legal aid, we've seen the dilution of judicial review as a remedy. We've seen obviously the major changes around the kind of SEN Law framework with the move from the Education Act to the Children and Families Act. But what would you say, I don't know, starting with you, Leon, what would you say have kind of been those major changes in terms of the law in this area?
In recent years, I think the big thing has been the move to try and include health and social care within the tribunal. And I think from a practical perspective and from many parents' perspective, young people, I think it's a whole, education, health and social care often overlap. And you see in tribunals sometimes residential placements will be part funded by education and part funded by social care, so they are parts of a whole. But there's a tension between that and the fact, in legal terms, there are different legal frameworks for them. And I think there's that tension, which in recent times I think has been interesting, and that will maybe an area which there'll be more case law as we go on. The national trial, I think, has helped those issues and resolved some of them for many families, but I'm not sure it has the teeth that it's required to make wholesale changes to the issue that we have.
And I think that's, partly, isn't it, because those powers that the tribunal has under that, well, it's now become a kind of continuing arrangement, hasn't it? But they're limited to making non-binding recommendations rather than orders. And so I think there's a challenge around that. And do you think there's also an issue about the kind of infrastructure of health and social care and education working together? And perhaps that's something that needs to change.
I think that's right. I think with health, certainly, where it's a different body, it's the CCG, and the case law from the upper tribunal says that CCGs don't even have a right to become a party. So it limits the persuasiveness of those recommendations, I guess. And certainly, even within the local authority, whilst one from the outside might say, of course, they're both arms of the local authority, the social care team and the education team, they often work very differently. Yeah. And that's an infrastructure problem for local authorities, I think. But I think the fact you have those different teams is quite, with competing considerations, is difficult. And the recommendations power is, as you say, the upper tribunal has made clear, it's a recommendations power, it's no more than that.
Sure. And David, I mean, under the old regime of the Education Act, we used to see some very common issues and common problems, and I think we continue to see those under the Children and Families Act. But are there any kind of new issues and emerging issues that have come since those reforms?
Yeah, I mean, I think I'll go to my my retirement still talking about specificity and quantification. It's just it's never going to go away, is it? I think, as Leon says, a lot of the issues are around the fact that we now have a more complicated relationship with other organisations. I mean, I always sort of remind myself that children and young people with SEN and disability, they have the benefit of the legal regime, which is the most protective, if you like, of any group in society. I mean, if you're a child with EHCP, you're the only cohort in the community who can actually say to the public body, please assess me through a prescribed process, please work out in a resources unconstrained way what I need, please write that down on a piece of paper, please let me go to an appeal if I don't like what you put, and then you have to give it to me. Nobody else in the community has those rights. So it's no surprise that people take those processes very seriously. And it's no surprise then that when we're arguing about the money involved in that, it all gets quite complicated. So there have been various points at which people have said, surely this ought to get simpler. Actually, it's relentlessly getting more complicated in terms of the processes and the arguments because of those interrelationships, because of health and social care and the complexity of schooling and so on these days.
Sure, and I was just wondering also, thinking about some of those other kind of areas of law that fall outside of SEN Law. I mean, in the days when I used to do legal aid work in education, it was a much broader scope. And actually we've seen it narrowed to just SEN, and issues like exclusions and things like that have kind of fallen out of that scope to quite a large extent. And we've of course also seen changes in the context of exclusions law. And I just wonder whether whether that's an additional challenge really when you're thinking about the support and the framework for supporting children and people with SEN.
Well, I think just talk about the exclusions and also a lot of cases around disability, not so much SEN. Very often the child or young person who's not getting the SEN support today is the one who's being excluded next week. So those regimes can never operate separately. And really our focus in the Noddy Guide is still on SEN and disability, but one of the things we might do in the future is to expand into those other areas because they're so interconnected.
Yeah, absolutely. And how do you see, I guess, just building on that a bit, how do you see the kind of Noddy Guide developing as we move forward? Leon?
I think what's quite exciting now is that there's a platform where people can ask questions or comment on provisions. So in something we've never had before, we get the odd email saying, thank you, we've been using the guide and thanks for all your help, but we don't have that sort of granular response to it. So I think we may add sections here or there, but what we might do is start to update to try and address common problems. If there's a problem that seems to be emerging across the country in different local authority areas, we can then address that in the next guide with offering our view on the law in respect to that problem. So I think that's what might change with the digitised version.
Sure. And I guess, why does it matter? Why is it so important that there is this kind of level of accessible information out there, both for those who are kind of advising families, but also for parents, carers, young people themselves? Why do we need it?
Well, I think it seems to have developed into the place to go to for SEN law, and the amount of emails we get from parents, but also when I work with the local authorities, the officers are using it every day. And I had a conference with the Department for Education 2 weeks ago, and one of the policy team thanked me for the guide because they were using it as well. So I think it's the place where people go to for the law, and there is a fair amount of case law that comes out of the upper tribunal now, and putting that in one place in an accessible format for people is helpful, in putting it into the themes. I hope it's helpful because we obviously spend a fair amount of time doing it, so we hope it's helpful for people. But it's the place where people can go for that, and as David said, it's becoming more complex.
Yeah, I mean, I remind myself in a way that the legal framework, I mean, in the end, the tribunal is making a decision about children and young people's personal situations, but the legal framework gives the parameters of that. And so if the case law, and then by extension of that, the Noddy Guide, gives a degree of consistency across the country, that's only a good thing. So that somebody, a parent who isn't represented is in as good a position as a parent who is represented, or a parent who is doing it first time as opposed to a parent whose child is halfway through the school system. There's a degree of consistency across the country and so on. If everybody's using the same resource materials, we are likely to have the same approach to when is an EHCP needed, what does SEP look like, all those sort of very standard, familiar questions. Whereas I think you asked me earlier on, Ali, about the olden days. I think in the olden days it felt a bit more random, a bit more of a jungle, because different tribunal chairs were doing, frankly, different things. So in a way, to codify that and provide it to everybody in a common format, I think is only useful.
Yeah, and I mean, certainly what we see at IPSEA through the advice that we provide through our helplines and the casework support that we deliver and the training that we also do, what we see is just, poor decision making and often unlawful decision making on the part of local authorities at the most basic level. So whether that is about the thresholds that they're applying when they're looking at whether or not to carry out an EHC needs assessment, or the format with which a request has to be made. So just really kind of bringing in their own criteria and their own internal policies, which are kind of not compliant with the legal framework. And I think that's a real challenge, isn't it? And that's a challenge that families are facing. And the only people that are losing out are the children and young people that are so desperately in need of this support. And I think anything that provides a platform and an ability to kind of access information in a way that is accessible and clear and, as you say, consistent has to be really helpful. And I guess thinking about those kind of challenges that we're seeing within this framework, as we said, similar to what we saw under the old framework with some new issues as well. What do you think the future holds in the context of SEN law? I guess what do you think it holds and what do you hope it holds? I think they're two separate things really, aren't they?
Yeah, I mean, there's been a gradual over years bringing together of the SEN regime, the education regime, the care-based regime, and the health regime. They were always present together before, but very much SEN was the focus of the SEN regime, and the others were peripheral. Now, as we've said already, they're coming together in national trials and EHCPs and so on. I think that trajectory will continue. There are national moves, aren't there, to integrate health and social care for adults. That is bound to happen ever more for children and young people. And those kind of collaborations are only going to be helpful, because instead of a battle about who pays for a residential place or who pays for the therapy or whatever it might be, they will become single decision makers, and that can only be helpful again. And that might even lead to fewer contested issues with local authorities and fewer contested issues with tribunals, because you get situations where everybody agrees this child or young person needs this provision, and basically the argument is about who's going to pay for it. And once we can make those kind of things go away, they're all government public bodies, so it's a sort of sterile argument.
Sure. And Leon, anything sort of to add to that in terms of where we're going in the context of SEN Law? I mean, it's all slightly uncertain because we know that there's this government review that's been very heavily delayed in terms of publishing a report, but what's your sense of where it's going?
Well, I was going to give something more procedural about the future, actually, about the tribunal. I think the amount of tribunals that remain contested on the day is far too high, and I think there are times, and it's partly local authorities are hugely under-resourced, and there's no critical eye on the cases that are coming through at an early stage. And I think what the tribunals tried to do over years, we've got now you have to have a mediation certificate before you can bring in an appeal, but my sense is it's quite a tick box exercise rather than something that everyone's actually engaging with. And I think it would be useful for everyone to consider all the issues at a much earlier stage to avoid a lot of tribunals. I have had cases, and this is no exaggeration, where you are in a conference with the local authority, and their school that they have suggested says that they don't think they're a suitable school, and that's 2 weeks before the tribunal. I don't know how that piece of information has stayed quiet for so long, but it also happens with parental experts sometimes. Sometimes they suddenly they'll ask for a lot and then drop very quickly when you get to tribunals. I think all sides, if you trying to mediate a bit more to avoid tribunal hearings, I think is a good thing. And I think maybe even things like directions requiring opposing therapists or opposing experts to have a conversation before the tribunal, because actually I'm always surprised at how much common ground there is between the parties, and there's actually only a small bit of dispute. So trying to get the cases not before the tribunal, and that will then sort of solve a bit of the logjam of the tribunals at the moment, because we're back to it at the moment. We're still getting some that are adjourned just because of judicial availability, and it will help that, I think. So that's my take on the future. I think the procedure could be reviewed.
And any kind of broader areas, I guess, of change on the horizon. So we know that the Human Rights Act, for example, is on the table for repeal. We've continued to see the kind of challenges in legal aid and in the context of kind of public law judicial review claims. I just wonder whether there's any concern about the impact that those kind of things are going to have in this field.
Yeah, I mean, SEN law has always sat in the middle of all these other areas of education law and health law and so on. They've all been chipped away one way or another, whether it's legal aid changes or process changes or whatever. SEN so far has remained largely untouched in that regard. But it is more vulnerable because the exclusions regime has become much less available to people in terms of challenging exclusion decisions. All of that kind of managed moves have become more the order of the day. That makes SEN vulnerable. It's in the middle of that, still so far untouched, but still vulnerable.
Sure. And that seems like a logical place for us to end. So thank you very much, David.
Thank you.
Thank you, Leon, and thank you for joining us.